criminal trial has wrapped up in New York. On Monday, the Karen Read trial gets underway here in the Commonwealth.
Joining us to discuss these two headline-making cases is former Massachusetts Attorney General Martha Coakley, now counsel for Foley Hoag. Thanks, as always, for joining us.
Hi, Ben and Erica. How are you?
Hi, Martha. We're well. Let's start with the Trump trial, if we can. Lots to talk about questionable business practices this week. But the prosecution has to convince the jury here it rose to the level of a criminal enterprise. How heavy of a lift is that going to be?
So start with the fact that you always have to prove beyond a reasonable doubt, and that with the unanimous verdict, every juror has to agree. So that's a big lift always. In this case, they have to prove the misdemeanor of the business records. And on top of that, they want to prove the felony crime, the campaign violations, to get the jury to believe he really committed a crime. So I think it's a heavy lift. We haven't seen a lot of the evidence yet. It seems like they're laying some good groundwork to give the jury the foundation of that. But that remains to be seen, obviously, and that's going to be up to the jury.
Okay, so you mentioned this, Martha. The defense just needs one juror to find reasonable doubt, and that, you said, is a heavy lift, and really showing that this payment was campaign related and not really personally family related. We heard a lot about that this week.
Absolutely. And look, mistrials are not that common. They do happen. I think it's more common that there's two or three, maybe, rather than one lone holdout. But it can happen. And so if it does, one thing to keep in mind is this judge and the prosecutor, if they wanted to release this jury, they could impanel again right away and start this over again. But obviously, defense would love to have a not guilty verdict. And second to that, a mistrial would be second place for them.
There's no shortage of evidence that Trump has violated the judge's gag order in this case multiple times. Are you surprised there's been no action from the judge yet on that?
This judge really has to be a master chess player here, right? Because he needs to keep control over the court. He does not want to give to this defendant, I think, what he would love, which is to send him to jail. And he would know that some delay that makes him the victim. These are all things I think the defendant would enjoy. So he is trying to maneuver to keep order in his court. He does have sanctions that he can increase. Before, he held him in contempt and sent him to jail. So watch that closely, what the defendant, who loves to push the line on this, does, and what the judge does or doesn't do on this issue of keeping control over this defendant.
Yeah, not easy, okay? And so, Martha, the Karen Read murder trial, we know opening statements set for Monday. The jury is not sequestered at this point. There's been so much media about this case. So how big of a concern is it that some coverage will get to the jury?
So sequestration is actually used less and less these days. I don't rule out that in this case, or maybe the Trump case, that a judge would look at that for deliberations. But keep in mind that now, because of people have their phones, they have access to social media, the focus is really on having trustworthy jurors, checking every day to make sure they haven't seen or talked to anybody or been influenced in any way. And we know in the past there's some jurors that have gone online, and defense counsel or prosecutors have pointed that out. So it really is more trusting the jurors rather than trying to sequester them, because it's a huge inconvenience for jurors. This trial is going to be a long time. I don't think judges sequester people these days unless they really feel they have to.
And quickly, Martha, I just want to ask you, are you surprised that we seated a Trump jury in half the time it took to seat a Karen Read jury?
It's interesting, isn't it? When you would not have guessed those odds starting out. But I think because it's going to be a long trial in the Karen Read case, and there were some people who, figured once they'd been seated, they didn't want to be. It did take longer. I still think both of them were done pretty quickly, given the high profile nature of each case. And so they're off to do opening statements on Monday.
Okay, Martha Coakley, thanks for your time and your insight as always.
Thanks. Have a good weekend.
Good night. You too.